Good afternoon. I'm Joyce with the Freedom to Read Foundation. We will begin our webinar now. Thank you for joining us for this litigation and legislative update from the Freedom to Read Foundation. We are a nonprofit legal and educational organization founded in 1969 to promote and protect the freedom of speech and the freedom of the press. We also protect the public's right of access to information and materials stored in our country's libraries, and to safeguard libraries' right to disseminate materials contained in their collections. In addition to litigation and legal advocacy, we support projects and programs to educate librarians, educators, and community institutions across the country. We also support initiatives and scholarship programs to improve intellectual freedom education for library science professionals and students. We hope that you'll visit us or join us online at FTRF.org to learn more. This afternoon, I'm glad that we have Deborah Caldwell-Stone, Director of the Freedom to Read Foundation, and our General Counsel, Theresa Chmara. They've been sharing these updates with FTRF trustees, members, and friends twice a year at our annual and midwinter meetings for many years. This year is unique, not only because we're together in person, but because the landscape is very different. Since the beginning of the pandemic and varying levels of quarantine and crises throughout the country, access to information and questions of privacy have become more challenging and have been at the forefront. Employers, employees, and students are increasingly working online. That is, if they have a job and the means to have internet access and tools to log in with. And at the same time, family members at home who may want to access books or information that they would typically get in person through their home library may have lost a way to maintain that privacy and to acquire the information that they're seeking. While each of us has been navigating these challenges, the challenges to materials, changes in legislation, First Amendment cases, and the need for litigation have not been placed on pause. This afternoon, I appreciate that Deborah and Theresa are taking time to share some updates with us. Once they are both done presenting, we'll have time for questions and answers, and I encourage you to enter your Q&A in the chat box or the Q&A box throughout our session. On that note, I welcome Theresa Chmara, our General Counsel, to take over.
Joyce, thank you so much for that introduction, and I'm really pleased to be here with everyone today. I am going to highlight just 3 cases today, although Freedom to Read has been involved in a number of cases over the last year, but I think there are 3 that highlight the different areas in which Freedom to Read becomes involved in litigation. And before I start that, I wanted to talk about the kind of roles that Freedom to Read takes on in litigation. Sometimes it would be as a plaintiff. In that case, it would be a case where there's perhaps a statute which would provide a direct legal injury to members of the foundation. For example, a statute that might make it unlawful to disseminate certain type of information which are held in library collections and which we would say are constitutionally protected. And yet, if they were to disseminate those materials, libraries in those states could be prosecuted. In that case, Freedom to Read would enter a case as a plaintiff. More often, Freedom to Read joins a case as an amicus. And in this case, they would join or draft a court brief that would speak to some issues that are of interest to members, even if there isn't a direct injury at play in that particular case. Additionally, Freedom to Read also offers background assistance, sometimes providing experts. This might occur, for example, in a censorship case where the court might need to hear about the educational suitability of a book that is being censored, or Freedom to Read might provide legal assistance in a situation where maybe a library has been sued and they must use their own municipal counsel who may not be as familiar with First Amendment issues, and we are able then to provide legal assistance in the background. But the first case that I wanted to talk about specifically is a case that raises issues of privacy and government searches. And this is a case, again, where Freedom to Read has participated as an amicus. Issues of privacy are very important to libraries and to our members because we've had cases in the past where law enforcement officials have come to libraries and asked for information about patrons without having search warrants. So this is an issue of great importance to libraries, and for that reason, Freedom to Read joined in an amicus to clarify some of those issues for the court. Now, originally this case started as a criminal prosecution. The defendant was accused of and convicted of sending funds to a foreign terrorist organization. He appealed that conviction and challenged the NSA's telephone metadata surveillance once he found out that evidence from that surveillance had been used by prosecutors. And Freedom to Read Foundation joined an amicus that focused on the need for a search warrant. Not that the government couldn't get access to information that it needed in terms of investigating criminal activities, but that to do so, the government or the law enforcement would need a search warrant. And that particularly, they should not make a distinction between metadata that was collected by the government and content or physical papers. So if a situation would require a search warrant for physical papers, then it should also require it for the metadata. Additionally, the amicus brief emphasized that when there are First Amendment expressive activities, which clearly are being monitored when the government is surveilling metadata, who are folks calling, who are they contacting, how long do those conversations last, who else in that sphere is being contacted or monitored. When that impacts First Amendment expressive activities, then the government must clearly protect those rights pursuant to the Fourth Amendment search and seizure laws. And finally, the amicus brief focused on the fact of how technology has become incredibly critical in the digital age. And we've seen that even more so, as Joyce pointed out, in these last few months, how much we are all relying on technology. And we've come to a point where we really can't do without it to function. And so the fact that that content or metadata might be stored by a third party doesn't obviate the need for a valid search warrant. And the reason this issue is very important, and one that Freedom to Read felt a need to bring to the attention of the court, is because there is an old case from the Supreme Court from the 1970s that held that where a third party had the information, there was no expectation of privacy in that information. And I think it helps to understand a little bit of background about that case. It was called Smith v. Maryland. And in that case, a woman had been robbed, and she then noticed that there was a car lurking in her neighborhood in front of her house. And then she started getting phone calls from someone who was harassing her and saying he was the one who had robbed her and would do it again. She was able to give the information about the vehicle to police, who were able to identify who the driver was of the vehicle, and then went to the phone company and asked for pen register data that would show whether that person had been calling her. And in that case, the Supreme Court held that because the third party here, the telephone company, had that information, that defendant didn't have a reasonable expectation of privacy. But the point that we were making in this case, and it has been made in a number of cases, is that things have changed. And there is, maybe you could have decided back in the 70s, okay, I won't use the telephone then. So the third party, the telephone company, won't have a record of my phone calls, but that's no longer possible in this digital age. The Ninth Circuit actually sort of hot off the presses in a decision that we've waited for many, many years. It's just been pending at the Ninth Circuit, but which did come down this month, did uphold the conviction because the panel held that the metadata collection didn't taint the evidence that was used to convict the defendant. But it did go on to say, unusually, because the courts usually don't comment on things that they don't need to make a decision, the panel did find that if it were to consider it, the issue about the unconstitutionality of the surveillance, that it would find that it probably did violate the Constitution. And importantly, actually relied on the amicus brief that we had joined to find that distinction between content and metadata is increasingly untenable. So at this point, we don't know whether this case is over or not because it was just handed down. So they still would have a chance to ask the Supreme Court to petition the court for cert. And so the Supreme Court could possibly be asked to weigh in. But this is where we are at this point. So that was a good result in the sense that I think the court has felt that it was an important issue and that it should comment even if it didn't need to in order to resolve the case. The second case I wanted to talk about is the Gibson Brothers v. Oberlin College case, which raises the issue of library liability for disseminating material. This is a case that started with an altercation between Oberlin students and a local store near campus. A student had tried to use a fake ID to purchase alcohol and was also trying to shoplift some alcohol. And there was an altercation between the clerk and the student. The clerk tried to take a picture of the student so he could pursue action. The student knocked the phone out of the clerk's hands and ran out. When the clerk ran after him, two other students joined in, and again, there was an altercation. When the police arrived, the students were arrested. They eventually pled guilty to assault, and the original student did plead guilty to using a fake ID. And they, as part of their plea deals, said that they did not believe it was a racially motivated incident. However, students on campus became upset about this. The Student Senate passed a resolution accusing the store of being racist and issued flyers at a peaceful protest that was held about the incident. At that protest was also a dean from the school who was officially there, according to Oberlin's administration, to make sure that the protests remained peaceful. But she did actually talk to a journalist and give the flyer. Again, the flyer and the resolution were all authored by the students, not by the administration or by the dean, but she did give a flyer to one of the journalists. Eventually, the store sued Oberlin College and the dean for defamation. And the court gave a jury instruction, the judge, saying that the jury could find them to have defamed the store based on negligence. And after the trial took place, the jury found that they had been defamed and gave them a verdict of $44 million, $33 million of which was punitive damages. Because of Ohio law on damages, there is a cap. So eventually that was reduced down to $25 million. On appeal, the Oberlin has argued that it was merely a redistributor and not an author, and thus the standard of negligence was inappropriate to apply that. And Freedom to Read joined an amicus brief that was drafted by the Reporters Committee for Freedom of the Press, addressing that standard because libraries are redistributors of materials. So the standard that could be applied to a bookseller or a library or a newspaper for redistributing materials is important that that standard be strict. And the amicus brief argued that it should be an actual malice standard. And under actual malice, you could only be found liable if you knowingly distributed false information, or if you did it with reckless disregard of the truth and not just negligence. So the brief argued that actual malice should be applied because it isn't practical for librarians and booksellers and others in that position to vet every single piece of material that they redistribute. And secondly, the argument was that even if negligence did apply to that kind of a situation, it would need to be more than finding them negligent for failing to verify information that was published. So, because again, as redistributors, libraries, booksellers, newspapers cannot independently verify all the speech that they regularly redistribute, and would have to engage in self-censorship on a grand scale in order to not be found liable for defamation. So at this point, these briefs were just recently filed, the amicus briefs. Curiously, the store did try to prevent the amicus briefs from being accepted by the court, and we were not the only amicus that was filed. There were others, but the court rejected that motion, and so all the briefs have been filed and the court will be considering them. And at this point, we're just waiting for that appeal, which is pending. The final case that I wanted to talk about is one that was resolved a little while ago, but that we were involved with, but I wanted to bring to your attention because there are other cases that have been percolating around this issue around the country, and one has just had a petition for cert filed with the Supreme Court, so we'll be seeing more about this. And this issue pertains to public libraries and their use of social media. So before I explain the facts of the case, I wanted to just say that these cases are not about social media where, for example, a library or another government entity simply has an informational page on social media. These cases only arise when there's an interactive part of the site. So it would be a public library that has a social media site, but also allows folks to post and to make comments. And it's risky to do that, to remove posts or to remove comments when there's a government entity involved in the social media page. So for example, the case that we had joined arose in Hunt County, Texas. The sheriff's office had a Facebook page and they banned a speaker, Ms. Robinson. She was a critic of the sheriff's office and posted critical comments. They said that they were removing her posts because they considered them to be verbally abusive and in violation of Facebook's community standards. And they also not only banned certain posts, but they banned her entirely from, in the future, posting anything. She sued, and during the course of evidence that was presented at the district court level, it became clear that positive comments were allowed, but critical comments were not. But the district court had found that because Facebook's community standards would have allowed Facebook to remove her comments, that the sheriff's office could also do that. We joined an amicus brief that argued that once the social media site is a government entity site, it becomes a designated public forum, and it's unconstitutional then to remove any content or to ban a speaker based on a disagreement with their point of view. And also that it was unconstitutional for the government entity to rely on a private set of standards to make that removal. And the Fifth Circuit completely agreed with that position. And it found that removing the posts because they disagreed with the opinion, or even if they just deemed the post to be inappropriate, constituted viewpoint discrimination because it was based on the content of her speech. And secondly, agreed completely that the sheriff's office couldn't rely on Facebook community standards because a private policy cannot govern a government entity's actions when that government entity has a constitutional obligation to uphold. So the case went back to the district court on a remand for a full trial. And the parties did then settle the case, but only because the sheriff's office had decided they would just shut down the social media site entirely. But they did agree in the future that they would respect First Amendment rights on any future site they might set up. And they also had to agree to pay $45,000 in attorney's fees. So risky to ban speakers, even though I've worked with libraries for over 30 years, and I know that libraries aren't banning viewpoints, but certainly I think libraries do try to keep the conversation civil and wouldn't want anyone on the site to feel offended by someone else's speech. But offensive speech is fully protected by the First Amendment, and banning speech just because it's disparaging or offensive is something that would create a risk of being sued and of litigation. So I just wanted to point out that there were two other cases that have held the same. One in the Fourth Circuit, where a county board member had removed a post from her Facebook page. And another case that you may have heard about in the news, which was the Trump Twitter case, where it was out of the Second Circuit, where he had removed any speakers or on his Twitter page that disagreed with his point of view. And he was sued, and the court found in that case that the fact that it originally was a private page did not matter, because it had become a government official page because there was so much business that was transacted on that page, where people were hired, people were fired, and policy statements from the administration were posted there. So it was effectively a government page. And because of that, you couldn't just remove someone that was making comments because he disagreed with them. And it didn't matter that those folks could have their own Twitter pages. It was important that where there was a government site, where it had become interactive and had been opened up to comments, that in that case, you can't, again, remove based on viewpoint. So this is a case that I mentioned earlier. They have filed a petition for cert with the Supreme Court. Now, the Supreme Court does not have to take cases. They take some, but not all cases. But I expect that we will be seeing more about this from other courts as there are more social media sites that are out there. So I will now turn this over to Deborah, but I'm happy when we get to the Q&A portion to answer any questions that you all might have. Thank you.
Thank you, Theresa, and thank you everyone for joining us today. Because we've reached the end of most state legislative sessions, all but 10 states are out of session, and most of those that are in session are dealing with special topics or veto sessions. I'm going to talk instead about broad trends in state legislation that we observed for the past year. Primary among these, of course, are the bills that we saw introduced that would facilitate the suppression and censorship of library materials and programming addressing LGBTQIA materials or comprehensive sex ed materials. These bills took two forms in the 2020 legislative session. The first was the introduction of unique bills called Parental Oversight Acts that would have supplanted the authority of library boards and library workers to develop collections and identify materials for the libraries by substituting the judgment of a parental oversight board, 5 parents who agreed to vet all library materials for their suitability for young people, with the idea that they would regard any LGBTQIA materials or comprehensive sex ed materials as inherently harmful or obscene as to minors, and barring libraries from distributing these constitutionally protected materials to young people without the consent of this parental board. Fortunately, these two bills did not pass in either Missouri or Tennessee, but an alternative form of this type of bill was introduced in a number of states, including Florida, Georgia, and Indiana, that would have removed traditional legal defenses or protections for librarians and educators for pandering materials that were harmful to minors. In essence, they would become very vulnerable to criminal and civil prosecution for simply distributing things like comprehensive sex ed or materials that a parent or a prosecutor believed were obscene as to minors, even though they were otherwise constitutionally protected. Again, none of these bills passed, but it represents a trend that we've been observing for a couple of legislative sessions. And we're very concerned that it will continue in the future. One other method that has been introduced as well is requiring criminal background checks. This is legislation that was developed to specifically target the use of the programming of drag queen story hours in libraries. The idea was that anyone who wanted to present a program to minors in a library would have to undergo a complete criminal background check. In the one state that introduced it in New Hampshire, they would have had to go through the state police and a number of hoops and pay fees just to present in the library. Again, that bill did not advance. The legislator deemed it inexpedient to legislate, but it represents this broader trend of trying to suppress materials that some find offensive or objectionable because they disagree with the content. Another trend that we observed in the states was bills that would impair library users' privacy rights. We were particularly concerned this year with a bill introduced in Michigan that would have amended the library confidentiality statute in order to allow a library administrator to release any and all records about a library user if it was alleged that the library user had committed a crime on library property. This kind of legislation would have really impaired the privacy of library users and left it wholly to the discretion of a library administrator and the local law enforcement. Fortunately, the Michigan Library Association took up the cause and negotiated a compromise that preserves library users' privacy rights. And that substitute bill was introduced this week in the Michigan legislature. So, but it is a trend that we observe that every so often there's an attempt to change library confidentiality statutes to facilitate access for law enforcement or for other reasons. And so for that reason, we are tracking that trend. Another trend that we're observing is mandatory internet filtering that goes far beyond SEPA. And probably the best example of this kind of internet filtering proposal in the legislatures is something called the Human Trafficking Prevention Act. And this is a bill that would not only affect libraries, but every single internet user and institution or entity that uses the internet, because it would require all sellers of internet-capable devices to install mandatory filterings at the point of sale. And the only way that the filter could be removed would be the payment of a fee by the user and the requirement that the user listen to or participate in a class that instructed them on the evils of pornography. This bill this is a model bill that has been introduced by advocacy groups that are anti-pornography. It's had amazing traction. We've been following this model bill in legislatures for over 3 years now. But despite efforts to educate legislators about the unconstitutionality and the flaws of the bill, it is continually introduced by legislators on both sides of the aisle. Fortunately, none has actually made it into law yet, but these are bills that we are concerned about for obvious reasons. We are still seeing the introduction in states of what we call mini SEPAs, which would condition the receipt of state funding on the use of internet filters in either school computer workstations or public library computer workstations. Such a bill was passed and adopted in the state of Idaho this year. A similar bill was introduced in the state of Washington, but failed to advance. Another hot topic in state legislatures is the regulation of social media content. Again, this is a place where there's been a model bill advanced by advocacy groups called Stop Social Media Censorship. It's being advanced primarily by conservative organizations who perceive that social media platforms and entities engaged in content moderation online are biased against conservative viewpoints, political viewpoints, or religious speech. These bills would actually make a social media platform or a content moderator liable for the removal of anyone's political or religious speech. They could be sued in the courts. They could be sued by attorney generals for the state who would enforce the law on behalf of the users. Again, these are bills that did not advance, but they represent a worrisome trend that we will be following. The other regulation of social media content that we're observing is a large number of bills addressing the publication of non-consensual intimate images, revenge pornography. And in most cases, we agree that though the non-consensual publication of intimate photos with an intent to harm the individual, to embarrass the individual, is something that should be addressed by the government. But often these bills are written so broadly that even libraries become liable for providing access to historic images that include nudity. Probably the paradigm of this kind of image is Napalm Girl from the Vietnam War, but there is a host of other content, both print and online, that libraries could be liable for if this kind of broad legislation is adopted. FTRF has participated in amicus briefs to seek to halt or amend such legislation so that libraries can continue to provide this content to their users. But we continue to see these types of bills introduced in state legislatures. Model campus free speech bills. Again, this is an initiative of conservative advocacy groups who perceive that universities are biased against conservative speakers. These bills are worrisome because they would strip educational institutions of their immunity under their sovereign immunity against lawsuit and make them liable for any free speech violation that could be brought in a court of law. They would mandate that the university or college punish anyone who protested a speaker that is perceived to disrupt the speaker's event. They would also mandate that the university could not take a position on any social justice issue or political issue. There have been a number of states that have adopted variations on these bills that require universities to open their campuses to all sorts of speakers. The more radical bills have not yet been adopted in many states, but there is a continuing campaign to get states to adopt these legislation. And finally, we're seeing, and this is a great trend, we're seeing increased legislation that would regulate and protect data privacy and biometric privacy. More specifically, we're seeing bills like the California Consumer Privacy Protection Act introduced in multiple states in the absence of federal legislation that would protect user data privacy. There have been a number of bills that have also been introduced that protect biometric data like thumbprints, face scans, iris scans. Many of them are modeled on the bill adopted by the state of Illinois called the Illinois Biometric Privacy Protection Act, which requires any entity that collects biometric data to obtain the consent of the user before that data can be used on a platform, online, or to manage that individual's access to platforms or even the physical building of a business. Next slide, please. We're observing a few trends in federal legislation as well. A strong trend, especially in the wake of the COVID-19 pandemic, that revealed how bad the digital divide exists in this country. Net neutrality and broadband access bills. There are a number of federal bills that are attempting to address the digital divide, the lack of broadband access on indigenous and tribal peoples' lands and in urban districts. So, of course, ALA and FTRF supports these initiatives to expand broadband access to all parts of the country and make it more than adequate for everyone. Another issue that has been before Congress this year is national surveillance issues, particularly Section 215 in the Foreign Intelligence Surveillance Act. Section 215 was due to sunset last year. It was extended for a number of months by Congress, but it did lapse this year on March 15th, 2020. So we no longer have an active Section 215 of the Patriot Act available to the FBI for use in foreign intelligence investigations. Two bills are before Congress, both one in the House and one in the Senate, that would reinstate Section 215. But because of the gridlock we're observing in Congress this year, it's uncertain at all if those bills will pass, and they will lapse like all bills in Congress on December 31st when the current congressional session closes. So it may well be that this will be the year that we no longer have to be concerned about Section 215 secret warrants being presented to libraries or online providers or other electronic communications providers. Online content regulation, like social media regulation in the States, is also a hot topic here. There are a number of bills that are comparable to the Stop Social Media Censorship model bill that is being introduced in the states in Congress. But more importantly, there is a lot of attention and activity being directed to Section 230 of the Telecommunications Act. This is the provision of the Telecommunications Act that immunizes third-party online access providers from liability for content that's posted by other persons, whether it's posted by users to social media or it's published by a website. This is the law that immunizes libraries and other access providers from liability for libel or obscenity, other crimes for simply providing a portal to the internet. Because of a number of factors. One is the conservative belief that they're being censored on social media. Other concerns are for the publication of non-consensual images or revenge pornography. And a third factor is the desire of law enforcement to be able to access internet communications without encryption. These initiatives have all been introduced to impair or alter Section 230. One is the Earn It Act. FTRF has signed on to a letter opposing the passage of the Earn It Act, which would require social media platforms in particular, but other online content providers, to adopt a set of best practices dictated by the Department of Justice in order to have access to the protection from liability under Section 230. This would impair cybersecurity by impairing encryption, It would impair free speech and may well impact marginalized communities whose speech could be classified by some as obscene for minors or inappropriate for minors, as we've seen with the legislation challenging LGBTQI materials in the states. This is an area of activity to pay attention to. Just as in the states, we have a number of federal bills that are attempting to regulate free speech on campuses. And also a number of bills addressing data privacy and biometric privacy, particularly algorithmic bias and facial recognition. Next slide, please, Theresa. So future awareness. State legislatures will reopen in December and in January. And we have no doubt that the restrictions on access to library materials that deal with LGBTQIA materials, drag queen story hours, and similar programming will be targeted by some form of legislation. Each time there is legislation introduced in libraries, show legislatures what the problem is, both from a First Amendment and intellectual freedom standpoint and from a local control standpoint. They seem to adopt the legislation in order to attempt to impose the restrictions on these materials. So it's important to monitor it. And we also expect the bills that strip librarians and educators of their defenses and protections under harmful to minors statutes to be introduced as well. We've seen a number of attempts to limit autonomy via funding controls or other forms of regulation of library boards. One initiative we saw it locally in Maine would have transferred full control of the town's library to the city manager, rather from the library board that had upheld the inclusion of LGBTQI materials in the library's collection. Fortunately, that measure was defeated by the voters, but that's another avenue to be aware of. Online content regulation, as I just discussed, we expect continuing legislation that would address internet filtering, social media regulation, and a new twist, regulation of what is viewed as fake news or disinformation. We're seeing a number of proposals to regulate what's called deep fakes and other materials that are seen as false or propagating disinformation. And these have to be carefully analyzed to ensure that they're not impairing free speech or online access to information. A new trend we're also observing is restrictions on the right to engage in peaceful protest. These legislative proposals are arising in the wake of the protests that took place and are still taking place surrounding police violence and Black Lives Matter. Some are barring the blocking of public walkways. Some require punishment, expand the definition of what is rioting, so that encompasses some forms of peaceful protest. We'll continue to monitor this initiative and make sure that we bring this kind of legislation to your attention. And finally, again, facial recognition and algorithmic bias are hot topics in legislatures, and we expect positive legislation to continue to be advanced in this area. That actually concludes my presentation as well. And I'm happy to take any questions on these trends or on specific legislation. Joyce, where would you like to begin?
All right. Well, I don't see, I currently do not see any open questions from attendees. I did have one, and I please invite all of our attendees, if you have a question, enter it in the Q&A or the chat box. One of the things I wondered, I'm guessing this would be for Theresa, historically, were there First Amendment limitations on whether speech is true or accurate? Or is this sort of trend against disinformation a new phenomenon?
Well, the Supreme Court has explicitly held that untrue information or false information is protected speech. So that, I mean, it is protected speech. It's not one of those types of speech that is unprotected. Now, defamation is different because that is a false statement about a particular person that harms their reputation in some way. That the court has held is unprotected speech. The other kind of unprotected false speech would be for example, advertisement where you're making a false statement about a product that you're selling that would entice folks to buy that to their detriment. So there are those particular categories of false speech or untrue speech that the court has held are not protected, but generally speaking, the court has held that false speech is protected. This arose in a case a few years ago where someone was out there saying he had received I believe it was a Congressional Medal of Honor or some sort of military honor. And the case went to the Supreme Court, and the court held that that speech was protected, and that the way to counteract that false speech is when someone discovers that it's false, then you put it out there that this person is not giving you the truth. It was a candidate for office, but he couldn't be prosecuted for it, basically.
Okay.
Does that answer your question?
It does. And I've found that interesting just as we start looking at social media cases, disinformation, the case of the president's Twitter page being a professional page. Yeah, it's interesting how it's shifting. So I appreciate your clarification. We have another question. This is from Crystal for either one of you. The question is, have you noticed any trends in changes to local, local library policy that either restrict or expand First Amendment rights in libraries? If yes, have there been any legal challenges related to those policy changes? Do you want me to reread that, or?
No, I can start with an answer. And actually, Theresa, you recall the policy I had you look at from the Wisconsin Library? There was and it depends on how you want to view this, but there is a very active anti-LGBTQIA advocacy group called Mass Resistance. And they have local chapters, and they've taken it upon themselves to try to work with library boards on the local level to alter library policies in order to exclude LGBTQIA materials and programming. And there's a library that has adopted this, I talked earlier about background checks. They've adopted a very restrictive background check requirement for anybody who is not working for the library, who is presenting programming to minors. The intent in adopting the policy was to bar Drag Queen Story Hour. That was the sole intent. They fueled it by showing the library board comprehensive sex ed materials that they claimed were obscene, but they were not. One of the books that was used was It Was Perfectly Normal. But ultimately, the library board adopted the policy with some amendments. And in looking at the policy on its face, and you have to understand there's a difference in how policies appear on their face and how a policy is applied under the law. And so a policy on its face may appear to be perfectly constitutional, but if it's applied in a way that is discriminatory or restricts speech, it could give rise to a lawsuit. And so this is one instance where we've seen local library policy adopted in a way that a local library policy adopted with the intent of restricting programming at the library dealing with LGBTQIA content. And at this point, we're not aware of its use in a way that could be deemed to be discriminatory or restrictive of free speech rights. So there hasn't been an avenue to raise a challenge. There hasn't been a plaintiff available to raise a challenge to the policy. But that's one example of how it's important to be aware of what's going on with local library boards and to be supportive of library workers, library administrators, and trustees that are working to preserve free access to information in the library. Another instance that we could also look at is not precisely library policy, but the effort to suppress the adoption of library policies that would facilitate equity, diversity, and inclusion. We're seeing this in Douglas County, Nevada, where there was a controversy when the library director simply put a diversity statement on the agenda for discussion by the library board that included the words Black Lives Matter. And based on that alone, there was a huge controversy. You may have recalled the media coverage by that of the sheriff's action in first saying that he would deny protection to the library. They could call some other 911 number because they used the hashtag Black Lives Matter. And we're now learning through public records requests that there was a call to defund the library altogether for simply considering a statement. There's probably nothing unconstitutional about any of that, but it does point to an intellectual freedom issue and an issue of speech on the part of the library workers themselves and the library institution itself. And so again, it is possible to adopt policies that are restrictive, and we can't always, or to be involved in a situation that results in a suppression of speech, as in Douglas County.
There's another example I might mention, Deborah, which is meeting room policies, which we've seen. There have been some tension over libraries that had policies that opened the meeting room. And once you open it, again, similar to the social media policies, once it's open, just like a social media policy is interactive, it has to be open to everyone, and you can't restrict on the basis of viewpoint or content. And we've seen libraries that were banning use of meeting rooms by religious groups. And the courts uniformly held that you could not ban a religious group simply based on the content of its speech being religious. We then saw, because the Supreme Court had not directly addressed this issue, that libraries were banning religious services as opposed to just religious groups entirely. So a religious group could use the library, but it couldn't conduct a religious service. And we saw a case coming out of California where the appellate court said, yes, you probably could ban a religious service, but the problem was the court also said, but you can't ban Bible study or discussion of the Bible or this or that. And when it went back down to the district court, the court held that just was entangling the court and the library into trying to decide what was religious service and what wasn't. We still, after that case, saw some libraries with that ban on religious services, and a group and a concerted effort went and sued 3 libraries, and all ended up settling to take out that ban. So again, I talked a little bit about putting yourself at risk as a library. And if you have a ban on a religious group or a religious service, you certainly are putting yourself at risk having that in your policy. So that would be another example.
Thank you, Theresa.
We have 2 questions, one that sort of follows along with that one from Barb, and then Karen, I will address the question that you had. Barb said, well, how does chilling effect enter into the conversation? Can there be a suit that claims that a restriction in a library policy has a chilling effect on the librarians?
That would raise issues of the rights of employees to engage in speech not otherwise outside of the boundaries set by the employer. And so it would turn on the right of the library employee to speak, which is a very limited right. While public employees do have a right to speak as a citizen on matters of public concern, their speech on the job, their speech activities on the job are subject to regulation and control by the employer, including the government. It's doubtful that there is if a library board adopts a policy that requires the library worker to adhere to a particular policy in regards to speech on behalf of the library worker would have to comply with it, and it would not be seen as necessarily chilling the speech of the library worker on the job. Now, there would be a different matter if the library worker were speaking as an individual citizen on a matter of public concern. But that is a fact-based analysis that could not, would have to depend on what is the overall, the circumstances as a whole of the situation. Most often we've seen these these employment speech cases turn on letters to the editor written by school teachers concerning a school levy, for example, or trying to use school facilities to communicate a political message and things, or comments made by an employee during while they were on the job about politics or an election. But we have not encountered that precise situation that you're proposing, Barbara.
Okay.
I agree with Deborah. I would just say that maybe the way to look at this would be that if, say, the board came in and told librarians, well, you can no longer give out this information, and not just removing material, but say telling a research librarian, if someone comes to you and wants to ask questions about certain things, you are not allowed to answer that. That would be a chilling effect, but the injury there the courts would see that injury being not the librarian's injury, but the patrons not being able to get that information. So speech would be chilled, but the lawsuit would have to come from the patrons who can no longer access information that's constitutionally protected and should be available to them. I don't know if that makes sense.
Barb did have a follow-up comment, but I do, before the end of our hour, want to address a question that Karen asked related to social media pages. Karen asked, can you say more about how a personal social media page becomes an official page?
So it became that it becomes that in the case of, for example, all the cases that I mentioned, where we can talk about the Trump Twitter page. So he started that long before he was in office, but he then began to use it as a government, basically as a government official. And that's when it becomes a government, a page that is subject to the First Amendment. Similarly, the Loudoun County, Virginia county board member who had a Facebook page, and she opened it up to comments, and it was an official government page. So even though she's using a private platform, she's still using it as a government page that provides official information. So sometimes I've given the example, a way to look at that is if you are looking at, say, a government county has some big issue that they're trying to resolve, and they know they are required to have open meetings, and they know that there's going to be overwhelming interest from the community, and they know that they don't have a county building in which they can have this meeting, and they use a local hotel to have the meeting because they have a ballroom. And the hotel owner says, that's fine, sure, I'll let you use this, but you know what, I don't really like Democrats, so you can't let any Democrats into the meeting. The government entity, even if it's using private space, just like the social media, in the social media context, they're using a Facebook page or a Twitter page, they're still conducting government business. And in that case, they continue to have an obligation under the First Amendment. And they cannot hold, whether it's a bricks and mortar meeting in a private location, and exclude people based on their content or viewpoint, just as on social media, you can't exclude if you have an official government page that conducts government business based on content or viewpoint.
Yeah, and I'll point out, I think one of the things that was cited is that Trump was actually announcing legislative or regulatory initiatives via the Twitter page, which contributed to the conclusion that he was using it for official government business. So
yeah, the National Archives have made the decision that it was all considered official and had to be, couldn't be destroyed or had to be.
yeah, absolutely. And Joyce, I think we should probably just go over, if everybody can indulge us by going over time for just a minute or so, we should follow up and answer Barbara's second question.
Yes, thank you.
And so the board passed a restrictive policy to apply to this library that we described in Wisconsin. Their background check policy was designed to exclude the outside threat. They were fearful, and I'm quoting from news reports at the time, they were fearful that drag queens would come over from Minneapolis and present drag queen story hours to young people. And it was a way of restricting access to the library's meeting rooms and without changing the meeting room policy in an unconstitutional manner. And it was intended to prevent the invitation of those, or to create barriers to allowing library staff to inviting drag queens to present story hours to the users. But it wouldn't prevent library workers from presenting their own story hours because the policy was designed not to apply to library workers. So that particular policy did not restrict the library workers' speech in that instance. If the library policy when Theresa described the restriction on allowing the library worker to answer reference questions, again, the chilling effect would not be on the worker, who would be seen as being required to comply with the administration's policy, but on the restriction imposed on the library user, who has a right to access that information. Am I confused things? Or Theresa, can you bail me out here?
Yeah, I agree with that.
Okay.
Yeah, thank you. That was helpful. Okay, on that note, I don't see any outstanding Q&A or chat questions. Theresa and Deborah, thank you both so much for this update. It's interesting and we appreciate the information. Everybody who joined us today, thank you for spending time with us and learning more about current legislation and litigation. We hope that you'll also join us at FTRF.org and take a look at our upcoming programs, webinars, grants, scholarships, etc. I hope everyone has a nice afternoon. Thank you so much.